So the Committee on House Administration will come to order. We do have a quorum present, and good afternoon or morning, everyone, as the case may be. As I begin, I want to note we're holding this business meeting in compliance with the regulations for remote committee proceedings pursuant to House Resolution 8. Generally, we ask members to keep their microphones muted when not speaking to limit background noise, and members will need to unmute themselves when seeking recognition. Members, please keep your cameras on at all times. Even if you need to step away for a moment, please do not leave the meeting or turn your camera off. I'd also like to remind members that the regulations governing remote proceedings require we cannot participate in more than one committee proceeding at the same time. At this time, I ask unanimous consent that all members have 5 legislative days in which to revise and extend the remarks and have any written statements be made part of the record. And hearing no objections, it is so ordered. Under Article 1, Section 5, Clause 1 of the Constitution, each House of the Congress shall be the judge of the elections, returns, and qualifications of its own members. Federal law and House rules give this committee the jurisdiction and the responsibility to hear election contests on behalf of the House. Over the last 100 years, out of the hundreds of congressional elections that occur each cycle, candidates have filed an average of over 2 election contests in the House per Congress. Consistent with this historical pattern, in this Congress, 2 election contests have been filed under the Federal Contested Elections Act and are therefore within the committee's jurisdiction. Today, the Committee on House Administration will consider an original resolution to dismiss the contest brought by the losing candidate in Illinois' 14th Congressional District. Before we discuss the resolution to dismiss that election contest, I'd like to briefly address the contest from Iowa's 2nd Congressional District. Last year's election in Iowa's 2nd Congressional District was one of the closest House elections in American history. According to the Iowa State Canvassing Board's final certification, the margin separating the 2 candidates was only 6 votes out of almost 400,000 cast, or less than 1/6 of 1%. Contestant Rita Hart properly filed a notice of contest under the Federal Contested Election Act on December 22, 2020, and contestee, Congresswoman Marionette Miller Meeks, filed a motion to dismiss on January 21, 2021. After a response to the motion from the contestant and a reply from the contestee, this committee voted on March 10th to postpone the motion to dismiss. On March 31st, the contestant Hart announced she would withdraw the contest. She explained in her statement, and this is a quote, "Despite our best efforts to have every vote counted, the reality is it's a toxic campaign of political disinformation to attack this constitutional review of the closest congressional election in 100 years has effectively silenced the voice of Iowans." Now, it's sad that a contestant in a properly filed contested election felt that she had to withdraw because of toxic and partisan rhetoric. Everyone knows how this process works. Over the past 100 years, Congress has adjudicated in a bipartisan manner almost 150 contested election cases filed by Republicans and Democrats alike in races nowhere near as close as Iowa's 2nd. Every 2 years, the Committee on House Administration works on a bipartisan basis to send observers to congressional districts at the request of both Republican and Democratic candidates in those districts. Just 4 months ago in 2020, the committee sent 63 bipartisan observers to 25 such districts. With that history in mind, it is profoundly disappointing that some painted this process as something other than simply fulfilling our constitutional obligation. After a review of House precedent in contested election cases in which the contestant withdraws, it's been determined that no House action is required to dismiss the contest. So I would ask unanimous consent to enter into the record a copy of the letter of withdrawal from contestant Rita Hart, mailed on March 31st and transmitted to the committee by the Clerk of the House on April 8th. Further, I will send a letter to the Speaker of the House on behalf of the committee, acknowledging the receipt of the withdrawal notice and the letter's entry into our committee records. This letter will be added to the congressional record to memorialize the steps taken by this committee to dispose of this contest. I will now recognize our ranking member, Mr. Rodney Davis of Illinois, for the purpose of making an opening statement.
Thank you, Madam Chair. Thanks to my fellow committee members. I appreciate you working with us to iron out today's details. I'm glad that both sides were able to reach an agreement on the outstanding administrative issues before us as we continue our work on behalf of the American people. While I believe there is a proper use of the Federal Contested Elections Act, this committee needs to be very cautious in how it uses this statute for two major reasons. The first is the United States Constitution. It gives states the primary ability to conduct elections. Using the FCEA to override state law simply because you didn't get the results you wanted is an abuse of power. The second is it's costly for the taxpayers. When this committee decides to act on this statute, many attorneys get involved, and it's our constituents that are paying for it. Again, as I've stated before, there are instances where the FCEA is warranted, but it's a process that should not just be used when you don't like the outcome of an election. Well, I'm glad the chair has called this meeting today. I wish we would have moved earlier and on our own to dismiss the contest filed against Congresswoman Miller Meeks, because this case was undoubtedly costly for the taxpayers. It's a case that should have gone through the courts, not Congress, if there were disputes. But Rita Hart and her attorney, Mark Elias, knew the only way they could be successful was going through a partisan process in the House. It turns out public opinion didn't agree with that, and actually for good reason. Congresswoman Miller Meeks has an election certificate in the state of Iowa. Same election certificate granted to every single other member of Congress. She was determined the winner of Iowa's 2nd District by a bipartisan thorough process. Bipartisan recount boards in all 24 counties, including a member from each campaign, and their agreed upon third member, conducted the recount. Following the recount, Iowa's bipartisan state canvassing board voted unanimously to declare Congresswoman Miller Meeks and grant her, to declare her the winner and grant her an election certificate by the state of Iowa. She won fair and square. I'm only sorry Congresswoman Miller Meeks had to spend the first part of her freshman year, which is difficult enough, trying to set up your office, hire staff, reach out to your constituents, etc., with this hanging over her head. The FCEA serves a purpose, but it should be used sparingly. I'm hopeful we can be more judicious in determining what is worthy of this committee's time and taxpayers' dollars in the future. I believe our time would be better spent if we used it to exercise our oversight role with the election process and other issues, instead of working to national elections, either with federal election contests or HR 1. If we focused on that, I'm actually certain we could find common to make this committee work for our constituents. With that, I thank the chairperson for calling this business meeting today. I yield back the balance of my time.
The gentleman yields back. Before calling up the resolution on the Iowa case, I would just note that if we don't like the Federal Election Contested Act rules, we should amend the act. Under the Federal Election Contested Act, you are not permitted to file a contest until you have a certificate of election from the state. Under the act, state law does not prevail, nor is a contestant required to seek state court remedies. If we think that's not the way it should be, we should change the law, not complain when we comply with the law. I would now call up the resolution before us that addresses contestant Lauren Underwood's January 21st, 2021 motion to dismiss the contested election case from Illinois titled Oberweis versus Underwood. I would ask that this resolution be considered as read as the original resolution for the purposes of amendment, and I now recognize myself for 5 minutes. On December 4th, 2020, the Illinois State Board of Elections certified Lauren Underwood as the winner of the November election in the 14th District by 5,347 votes. As was his right, on January 4th, contestant James Jim Oberweis filed a notice of content under the Federal Contested Election Act to dismiss, citing two grounds. First, contestant claimed the contestant did not timely serve the notice of contest, and second, the contestant failed to set forth with particularity, as required by 2 USC 382B, grounds sufficient to change the result of the election. As the contestant's claims warrant dismissal on the merits, the committee will exercise its discretion not to address contestees' arguments regarding the alleged failure of timely service. The committee should vote today to dismiss the election contest in the 14th District for failure to plead facts sufficient to change the election's outcome. If all of the contestants' factual allegations were true, he has not shown that he could overcome his 5,347 vote deficit against contestee Lauren Underwood. Because contestant has not alleged that the number of votes legally in dispute is sufficient to alter the outcome of the election, the committee finds that the contestant has failed to make a credible and specific claim that he is entitled to the office. I therefore ask the members of this committee to support this resolution by voting to report this resolution favorably to the House. And I now recognize the ranking member, Mr. Davis, for any statements on the resolution he may have. Mr. Davis, you are recognized should you wish to comment.
Madam Chair, again, thank you for holding this hearing today. I'm glad that we're able to finalize the efforts to unseat Congresswoman Marinette Miller Meeks. I'm glad to work with you and the committee on issues moving forward. Look forward to any legislative language that you or any of the members of this committee may put forth on changing the Federal Contested Elections Act. And I also look forward to working with each and every committee member on properly exercising our oversight responsibilities in the future instead of wasting our time on a contest against Congresswoman Miller Meeks. And with that, I'll yield back.
Does any other member wish to speak on the resolution? Seeing no one, then all those in favor of the resolution will please unmute and say aye.
Aye.
Aye. Members who are opposed, please unmute and say no. Hearing no opposition, the chair believes the ayes have it and the resolution is agreed to. Without objection, the motion to reconsider is laid on the table. This concludes the business before the committee today, and without objection, staff is authorized to make any necessary technical and conforming changes. I'd like to thank everyone for their participation. I appreciate everyone's work as we have now finished all the contested elections work for this Congress. Therefore, this meeting of the Committee on House Administration is without objection adjourned, and please have a good day.